and the southernmost two atolls uprising, and in one incident, entire island was forcibly removed, and they still have been continuously advocating for their rights and possible compensation for what had happened to them. And in addition to that, such a commission should also include the 1988 mercenary attack by Tamil Tigers with the help of certain Maldivians on the Maldives population, which has seen 19 lives being lost. So I hope I take the advice of the member of the commission. I think it's a very useful observation and suggestion, and I will take that suggestion to the government of the Maldives for its deliberation. With regard to the question of the budgetary issue of the Police Integrity Commission, the current practice is that the entire budget of the Maldives Police Service, along with the Home Ministry and the Police Integrity Commission, goes together to the Parliament. And as any other piece of legislation, this particular piece of legislation may need further improvement to address any deficiencies that prevails in that particular context. And I duly take the observation made by a distinguished member of the committee, and we'll try to address those concerns as well. With regard to the number of people being sent for prosecution by the Integrity Commission, I again take the observation made by the honourable member of the committee, and I would, for one person, we'll see what are the possible explanation for the lack of the cases that is being sent for prosecution, and what possible expertise or assistance that is required for this particular commission, although I can only make a recommendation, and I hope that this will in future may address certain difficulties or deficiencies that exist with the functioning of this particular commission. Coming back to the question of the victims relating to the actions by police and defense force, I must say that the mandate of the Police Integrity Commission is only to look for the functionality and the way that the function being discharged by the Maldives police force alone, and not the Maldives defense force. And for any such incidents, I would assume that other mechanisms that exist within the judicial and legal system of the country will come into operation. Hence, it will go for Maldives police force to investigate, as in certain past incidents it has happened. And again, the Maldives Human Rights Commission should also fall within that regime. And the Maldives legal and judicial system as overall will be the overseen mechanism for any action that is being carried out by Maldives Defence Force. Other than that, to my understanding, there doesn't exist any particular form of mechanism to address any shortfall by the Defence Force. To the question relating to anti-terrorism bill, I apologize for not answering in the early session. Of course, this was raised yesterday as well. Honourable member of the committee has raised the question very validly. It is the penal code itself is a more bulkier piece of legislation, but which is now in somewhat moving. But I must say that it is not a speedy process. It has taken, I think, almost 9 years now in the Parliament, and only the current debate in the country might somewhere have forced members to again to act quickly on this matter, and hence the committee that is revising this particular bill has said that they have now taken action and speed up their work, and they hope to be complete within 2 months. In relation to anti-terrorism bill, much a smaller piece of legislation, presumably in comparison to criminal procedure, penal code, has taken about 4 years, and I would assume that probably this is due to a technical assistance that may have required in the drafting stage of the bill, and I would gracefully take the distinguished members' observation that I will try to push for the passage of this bill as soon as possible. I guarantee for that. This is, again, important in relation to our commitment to international governance and as well as domestic and international needs. For the sorry. Coming back to the question of certain forms of sentences being awarded or being given by separate courts, here I would like to give an explanation of the Maldives judicial and legal system. Maldives judicial and legal system does not have a separate form of a court system where you witness in some other Muslim countries such as Malaysia, for example. They do have alongside civil, what they call a civil court system or civil legal system alongside with Sharia court system. Maldives has one legal system, and it is a fused system where the courts have the jurisdiction to hear both civil and Sharia matters as a practice, and there's no separation in line with Sharia offences and civil offences. For example, the civil court would always have the jurisdiction on all matters relating to civil offences, but those who comes from common law jurisdiction would understand when you say Muslim civil law would only meant that of a family. Is not the case, and all other matters uncodified in the same court. Family court, there is a separate family court in the Maldives for the purpose of a speedy judicial process only, and this particular court only hears matters relating to matrimony, divorce, marriages, and of course alumni and all other matters relating to children. To Ms. Diane.
Thank you, Madam Chair, and thank you, members of the committee, for the additional questions you have raised and also further clarifications on questions you raised yesterday that we were perhaps not able to attend to. With regards to the reporting and treaty reporting, I think I will request my ambassador to comment further on that. We do welcome the comments that we should try and adjust in order to have treaty-specific reporting, and definitely, despite our limitations in terms of capacity and resources, we take that into consideration and we'll be looking into that further. On the issue of the Human Rights Commission and membership being limited to Muslims, that is how the legislation stands at present. That does not obviously preclude the fact that we may be able to bring in changes into that legislation in order to ensure that non-Muslims can also sit in the commission. But actually the issue has not arisen as such in our community because, as explained earlier, it is a homogeneous community whereby all Maldivians have been historically Muslims. We do take into fact the consideration there's a lot of especially migrant workers coming into the country who are working there, who are non-Muslims in modern-day Maldives, but they're not settled as communities as such. They're sort of mobile communities in terms of the fact that they come in, work there for a specified period of time and leave. The other non-Muslims come into the country specifically tourism-related, and they're, again, not part of the community of Maldives as such. They're very separate on resort islands, come on holiday and leave. So I think these issues are not issues that we have had to grapple with as such at present, but I'm sure these are issues we would need to be grappling with in future. Have raised in terms of looking into how to address these. again, on the issue of torture, I think the Minister has a delegation to establish with consideration. I just want to highlight, though, that given the political situation in the country, it has been extremely difficult to establish any independent commissions looking into any issues at present, because everything is extremely politicized, and it always has become a matter of which political side you're on or who you are trying to sort of go after in terms of alleged crimes that may have been committed in the past. But I think it's an issue that the country does need to deal with and come to terms with. Our own viewpoint on the delegation is we should try our best to address what's happened in the past, but I think we do need to look ahead, because as a country, I think we have been trying to point fingers and looking back into the past and being unable to move ahead in terms of going on with our lives. But definitely very much take into consideration the points that you have put across. I think the Minister mentioned about the anti-terrorism bill and also the anti-torture bill, the penal code. There's a lot of legislation which seems to be stuck in our parliament. And again, this is largely due to the politics of the situation. Following the 2008 change, when President Nasheed came into power in parliament, while he had at some points not clear majority in parliament, but he did later on have very clear majority in parliament. Had there been the will in the government at that point in time to push through legislation that we required to strengthen our democracy and to ensure moving ahead, especially in the area of human rights, I'm sure we could have seen a lot of progress being made, but unfortunately we did not. And as many of you are aware, President Nasheed came in with the aspirations of a lot of Maldivians that he would bring in rapid changes in terms of consolidating our democracy. But unfortunately, the situation did not work out that way. And subsequently, the events that led to the transfer of power as well. This government, we're definitely committed and dedicated to pushing through these legislations. And as part of the delegation, I would like to commit to saying that we would definitely lobby and work for that when we return back home. Just to give you that, it's not an easy process. There's a number of parties in this government. It's a coalition government. While we have tentative numbers, it's not such a clear and easy task within Parliament as well, but it's definitely something we will be working for and look forward to going ahead on that. I think on the domestic violence legislation, I don't have all the detailed information that was requested. I was personally myself very much involved in putting this act together, consulting with the different parties and consulting with NGOs and all the relevant stakeholders on the anti-domestic violence legislation. Definitely it's a criminal offense. While there are fines, there are also prison sentences in there in terms of how to sort of address the issue of adequate punishment for perpetrators. I would request my embassy here to provide further information on that, because I think it would not be fair for me to go into details which I do not have at present. On the issue of corporal punishment, I've got the Children's Rights Act here with me. It's Article 10 of the law, which was enacted in 1991, if I'm right. The wording is quite vague in that it says that there should not be any punishment given to children which could cause them psychological or bodily harm which is not apt for their age group. So again, this is not a very recent law, and perhaps at that time we were not dealing with these issues of corporal punishment. Again, I'm not aware of the details of the Education Act, but I think we would look into, and it's an issue, something that we will consider, and we will look into strengthening the legislation in this area when we go back home. As we mentioned before, it's not widespread. Instances do occur, but if there are additional steps that we can take to address it, that's definitely something that we would want to go ahead with. I think on the death penalty issue, perhaps the head of delegation would wish to add further as well. The sentence is there. It is actually, the system was one of pardoning prior to that, and we called this an unofficial moratorium because it's not officially there in any legislation as such. So the death penalty exists in the Maldives. There was an unofficial moratorium which continues to stand at present. The legislation, as I understand it, is to remove the power of pardoning and to sort of ensure that the sentence is carried out. That's something that we are definitely concerned about and we would wish to look into. And as the committee members have raised many times, studies have shown that the death penalty itself does not deter crime. And in our country, there is an issue of crime linked very much with drugs amongst young people, and we believe we need to really, we have been analyzing and studying the situation. Obviously, we have not been able to take adequate steps to address young people going into drugs and into crime, and thereby preventing this escalating crime in our country. But we take your point that this is what we do need to look into. I'm not able to commit as such on the death penalty issue because it's a highly sensitive issue, and obviously the national stakeholders would have very much a say on it. But on our part, we are concerned that this discussion is back, and we do understand the sensitivities and the fact that this does not solve the problems that we are facing at present. In terms of the reservation to Article 18, which I understand is extremely sensitive, as I mentioned earlier, it is the wish of our society and people. And why I say this is because the 2008 Constitution was drafted by a special majlis, which was put into place. How many members is it? How many members the special majlis?
50.
Yeah. The special majlis is constituted just for redrafting the Constitution, and it is a large assembly, representatives of the people, and they chose to put in this clause in terms of the fact that Islam is the official religion of the state, and also linking citizenship to being Muslim, which I think, as I explained to you, has become very much part of Maldivian identity and something that Maldivians wish to retain. And that is why this has come in, and this is why we have to put in the reservation into the article. We understand issues there in terms of perhaps people being denied their citizenship, but this matter has actually not arisen as such in the country, because while we say that there's no, people do not go around checking who is practicing Muslim, who is doing what. I mean, people are free to practice their religion as such. So the question of having to give up citizenship for a Maldivian who has renounced his religion or no longer practices Islam has not arisen as such. But the other way around, whereby Maldivians coming, non-Maldivians from outside coming into the society and settling down or living or marrying, getting citizenship is an issue for non-Muslims, and that's something I believe that we do need to consider for the future. So I will leave my comments on that for now. I think finally, the Honourable Member asked about the kind of Islam. Traditionally, Maldivians have been Sunni Muslims belonging to the Shafi'i, in the more homogenous society. We didn't have the other sects being practiced or Shia Islam being practiced in the Maldives. So this has been the way it has. And as you mentioned before, many of our documents, while the Constitution says that the official religion is Islam and does not say a particular sect as such, there are other laws and documents in the past that specified Sunni Muslim earlier on. I do not have the additional information on that, but I think the head of delegation may wish to add to that. Finally, definitely we will come back on providing information on the domestic violence and also gender women in terms has been doing. It is, I think the question was raised yesterday. We did not get back on that. I think the figures do not show huge numbers of people being prosecuted or tried for this crime or punished, but definitely as a Muslim country, that's not something that's allowed in the country. I think I've covered most of some of the issues that were raised by the honourable members of the committee. If there's any additional clarifications, definitely our delegation would be happy to get back to you, and I'll pass the floor to the head of delegation.
Well, thank you very much. With the permission of the Chair, again, coming back to the first question that we had in this morning, with regard to the provision of the international covenant practically being implemented domestically, I'd like to give an explanation here that covenant be enforced in the Maldives through a piece of legislation passed by the Parliament. That is one of covenants being invoked. For example, in 2010, the then President Nasheed arrested Honorable Yamin, Member of Parliament, and Mr. Qasim, as well Member of Parliament. In their arrest, I was representing them at that time as a lawyer at Supreme Court, and we had the opportunity to invoke the international covenant on the very covenant that we are ICCPR. I'm glad to notice that the Supreme Court in its judgment has referred to this particular convention and has said that the arrest and detention were arbitrary, and the Maldives courts are subjected to these conventions. And as well, it has explained to the right of a habeas corpus and very broadly has given its explanation in particular judgment. And in much later, in 2011 again, when President Nasheed again arrested several politicians, including myself, again the Criminal Court of the Maldives referred the same judgment and asked the relevant authorities to release the detainees. In this perspective, I would also like to draw the attention of the members of the committee to Article 68 of the Maldives Constitution, which very interestingly has given explanation that a court or tribunal shall promote the values that underlie an open and democratic society based on human dignity, equality and freedom, and shall consider international treaties to which the Maldives is a party. So here you have very interesting provisions in the Constitution. On one hand, when you have Article 4 and Article 16 and Article 10 of the Constitution, which subjects all laws to Sharia law, it also gives a wide range of options and opportunities to invoke other open democratic and international treaties. So the answer is yes, there are instances where the court has assumed, I would say in some instances very vigorously, the rights that is embodied in international treaties while defending the rights of the citizen in the Maldives. But the nation, and they've been trying to best harmonize both Islamic law and modern democratic values that is found on international treaties as well as other democratic societies. But in doing so, it is also mindful of to what extent it can also retain the features of the Muslim law. And the question that is raised here is understandable, but equally, the Constitution very clearly says Islam is the main source of all laws in the Maldives, and therefore the offences that is being raised here or that is being prescribed in the Maldives embodies both common law as well as Sharia offences. And homosexuality is one of the offences that is prescribed under Sharia. And the penalty that is available for certain offences includes flogging, and that's the reason why it is being retained in the Maldives judicial system. Again, I would like to stress here that there is no discrimination in terms of implementation of these punishments between male and female, be it flogging and other punishments. The concern was raised by the submission that on the number of cases that have been investigated, we found more female being subjected to this form of punishment than male, and probably this is one area which we will have to conduct further investigation and studies. And as it has been highlighted, the Mahdis belongs to a Sunni faith, traditionally the Shafi'i sect of the Muslim faith. And in some instances, though the Article 4 and 2 doesn't specifically provides it has to be a Sunni Muslim, but in other provisions of the Constitution, instances are provided where it has categorically said that also, interestingly. For example, Article 72 of the Constitution is stating the criteria of members of the Majlis. It states, for example, it has to be a Sunni Muslim. So this is one instance which has stated that. Is there other questions? Coming back to the question of the testimony of female witnesses, again, I must say that we are in the process of trying to further advance the legal system in the country. As it is, I have repeatedly been saying, the country introduced 2008 Constitution with the hope of introducing a more open and democratic society with a very progressive Bill of Rights. In the same way, the Parliament has been trying and struggling to introduce several other pieces of legislation that are required to implement the things that has been provided in the Constitution. Unfortunately, we find ourselves up to this date many pieces of legislation lacking to provide to further strengthen the rights that are provided in the Constitution. For example, the country still hasn't received a proper criminal and civil procedure code. And in the absence of the criminal procedure code, both the courts and the prosecution system, as well as the investigation authorities, struggle to meet the challenges that it daily faces within the system. In the same way, it also doesn't have a proper evidence code. The current evidence code is just about a page, one-page document, which very briefly states that in such matters Islamic law will apply, and in certain other matters the circumstantial evidence also takes place. So probably in this Evidence Act we will find answers to the question raised by honourable member of the committee. But again, even now also, it is in very limited circumstances that these discriminations are applied, as Muslim fuqahas and jurists applies in other circumstances. For example, in instances of adultery and fornication only. But in other instances, female witnesses takes over male witnesses. For example, in instances relating to children and their welfare, this is, of course, substantive law. But on those instances, there are instances where male witnesses carries less weight than female witnesses. So I think if there's no additional issues, we would still be happy to answer those questions. We hope that we will always be able to meet our international obligations while also trying to retain the features that is embodied in the Constitution. It is not for us only to decide and to say that this should be the way for the people of the Mahdis. It's a much larger issue, and most of the issues that is being raised here is very valid questions with regard to our commitments to international treaties. I recognize that, but I also want to draw to the attention of our honourable members, being a very small country and a country which is struggling a huge change over a very short period of time. There is a real question of the capacity in terms of both human resource infrastructure as well as the secondary legislation. And I hope the incoming days will be able to provide answers and solutions for those questions that is raised. But yes, with regard to the question of the torture victims, I think there's a very pragmatic answer being given, and I will take that to the country, and I hope to find a solution for all the victims that has your grievances. Thank you. Thank you, Madam Chair.
Thank you once again to the distinguished delegation for adding more detail to... Yes. I thank the delegation so far for the additional information they've given us. I see that there's one member who wanted to take the floor again, but we are running a little behind time. So if it's not a long question, we'll take it, but otherwise we can entertain it in the second set.
Thank you, Madam. I'll make it short. And I mean, if we're not wasting time, because I would have had to raise this in the second half in any case, because it suffuses the whole discussion for part one and part two, and that is that famous reservation. And I just want to add one dimension. I'm not inviting a response from the delegation. They've made their views perfectly clear, but it's incumbent on me, in the context of our work in the committee, to ensure that we have in our record our concerns with regard to the reservation to Article 18. We have, as I'm sure the delegation knows, adopted a general comment with regard to permissibility of reservations and how such permissibility can be assessed. It appears rather clear that the reservation to Article 18, as laid out at paragraph 109 of the core document, it does not comply with the requirements for a permissible reservation. In the first place, even taking account of explanations given by the state party, the formulation of the reservation makes it appear to include, to reserve with regard not only to Article 18.3, but also Article 18.1. The reservation says the government, the application of the principles in Article 18 shall be without prejudice to the Constitution. Now, on the face of it, that appears to embrace 18.1. In other words, it appears to embrace a non-derogable right, which is the freedom of belief or religion, not its manifestation, but the core element of the belief. Now, if that's not the intended effect of the reservation, at a minimum, the state party should consider making some form of appropriate declaration explaining to other state parties and the committee that it has no intention in that reservation of limiting the non-derogable right in 18.1. But that would be welcome. But of course, what the committee would like to see would be the entire of the reservation withdrawn, because it would seem, at least to me, that the reservation also violates the requirement laid out in the general comment that reservations must be specific and transparent, and they must give guidance to the rights holder as to their impact on a day-to-day basis. But a reservation that simply says Article 18 shall be applied without prejudice to the Constitution, and then when we recall that the Constitution has what I'm calling the Islamic override, and I mean no offence, that's just to capture the provision, it's not at all clear which elements of behaviour are or are not being impugned. And so therefore it seems to me that the test that the reservation must be specific and transparent is not met in the case of this particular one. And so ultimately I'm left to the conclusion that the only correct approach for the state party under the covenant would be to wholly withdraw the reservation. Now, you've made your position very clear. I simply put that into the record. I recognise that you may not feel the need to respond again. Thank you.
Thank you, Mr. Flaherty, for that intervention, and hopefully the delegation might return to it in the second part, which I tend to now. We shall now address the issues in the list from number 12 to 25, and for this I'm going to call on members of the committee to pose questions and raise points of clarity. The first person on my list is Ms. Vatefal. You have the floor.
Thank you, Madam Chair. I'm responsible for questions 12, 13, 14, 19, 21, and 22. And there are 4 issues. 1, that's in question number 12, the issue of the 24-hour rule. That's when people are in police custody, and we know that it's not of police discretion to keep people longer than the 24 hours. But we have information that people stay longer in police custody, and we want to know what measures you are going to take to prevent this. The second issue is on the evidence, and you already mentioned the Evidence Act, and we welcome the bill which is tabled at Parliament to be adopted, and that pending the adoption of the bill, other evidence is already accepted by the court. You have stated in your replies. But can you mention cases in which the court has accepted other evidence than confession? Because you have stated that pending the adoption of the evidence bill, the court has already accepted forensic evidence, photos, and so on. So maybe you can name the cases in which this has been done. We also, and the third issue is on the segregation of suspected person and convicted person, and also the adults and the juveniles. You talked about the new juvenile facility. Maybe you can elaborate more on that. If there is also a segregation between boys and girls. And I don't know how to talk about the last issue. That's on the reservation. And that's on question number 19, 21, and 22, because members have already touched upon that issue. But still, having a reservation on Article 18 has consequences on other articles of the covenant. We think of Article 2, Article 27. So there are some articles in the covenant which said no discrimination, and you have to, on the basis of religion. And if people can't have other religions, how do you deal with that? Maybe you can elaborate more on that. And also that pupils in school can't opt out of Islam because it's mandatory. The teaching of Islam in school is mandatory. So maybe you can also elaborate more on that. So those were, at this moment, my questions, Madam Chair. Thank you.
I now give the floor to Mr. Flighty.
Thank you, Madam. I'd like to raise points concerning issues 15, 16, 17, 20, and then one additional one. In issue number 15, we asked about the prison system and the prison situation, and I'm grateful for the response we received. I'm still left a little bit in the dark about the actual situation in prisons. And that's not particularly the fault of the delegation. It's just in the totality of information that's been brought to our attention. There's a lot of information with regard to, let's say, the conditions and the treatment of people in police detention, but not a lot about people in the prison system. So I'd be grateful for some more information on how prison conditions are being improved, concrete information. In other words, beyond just saying that you're complying with the findings of the independent monitoring mechanism and so on. We've had a couple of points brought, not many, we've had a couple of points brought to our attention specifically. One had to do with the categorization of prisoners and the general issues of prisoner management, respectful rights-based prisoner management. It'd be good to get your response on that. And also, there appears to be a long-standing problem of isolation cells and related abusive practices, or so we've been told. And it would be good, I see the delegation shaking its head, but if you could confirm that, to the extent, there may once have been a problem, that it's gone now, that would be helpful. And finally, I would welcome some detailed information on the contents of the Prisons and Parole Bill and information as to its status and the likely time for its adoption. So that's it with regard to issue 15. Turning to 16, which raises issues of legal aid, I'll be very brief here. I'd welcome information on the legal aid bill in the same fashion. If you could give us a sense of how what it does, to what extent it is a vehicle to ensure respect for Article 14 of the Covenant, and other elements of the Covenant, and what's the likely timeline for its adoption. Turning then to issue number 17 with regard to the judiciary, and again here issues of the judiciary have arisen throughout our engagement over the last day, judiciary, and that's very well. I notice that you and everybody else is of the view that the Judicial Services Commission is not in good shape. You're very direct in paragraphs 102 and 104 in your view that the Judicial Services Commission is in need of a radical adjustment. But I'm struck that in a paragraph 103, having said this, you then say that the Judicial Services Commission is busy working out its strategic plan and you will implement that plan when you get it. Now, you'll understand why I'm struck by the seeming inconsistency of those remarks. On the one hand, you don't believe the JSC is up to the job, and on the other you say you'll implement its plan as soon as it gives it to you. So I'd be grateful for a sense of what you are doing substantively to reform the Judicial Services Commission and address the deficiencies that the state and others have identified. Moving on, and it's still related to the JSC, I'd really like to get a better understanding of the issues relating to the engagement of the JSC with Judge Abdullah Mohammed. Now, we're not here to particularly examine Judge Abdullah Mohammed. I'd have to say we've received so many expressions of information and with regard to the practice of the judge that we could devote a whole day to those, but I don't think that's appropriate. But I'd like to know, is it the case that Judge Abdullah Mohammed was found guilty of malfeasance in his judicial function and that the JSC then declined to apply any form of penalty? It would be good to get clarification on that point of fact. Turning more generally to the makeup of the judiciary, information has been put before us to the effect that 6 of the 7 Supreme Court judges are experts in Sharia but in nothing else. That they are not versed in the common law and other dimensions of knowledge and skill required for their high office. Now, I don't know if that's true or not. I'd be grateful for a sense from the delegation if indeed that is the case. And, well, if it is the case, what action is being taken to make sure that the appropriate amalgam of skills are represented on the bench. if there's an issue in the state party that there simply aren't enough appropriately skilled people to take on the judicial function, I wonder, has the Maldives adopted the procedure that many other similar states have of bringing in judges from elsewhere? It's commonplace in smaller states. It raises its own concerns, but it's not inherently a bad idea. And so I'd be grateful for a sense of whether this has been considered, would be considered, will be considered. Penultimately, with regard to the judiciary, it has been suggested to us that there are no women serving in the higher courts at all. Not a single woman on the bench in the higher courts. So it would be good to get a sense of whether that's the case, and indeed, if there is a problem of representation of women at the higher levels of the bench, what you are proposing to do about that. And then the very last issue I wish to raise with regard to item 17 has to do with what seems to me really very good report that the International Commission of Jurists delivered with regard to the state of the judiciary, and Mr. Despuy, who was the former Special Rapporteur, chaired that investigation. And I think the Maldives is fortunate to get such a high-level review of its judicial system provided, albeit from a non-governmental source. I'd like to ask to what extent the ICJ report is informing the current reflections by the State Party as to how best to reform its judiciary. A lot of issues there, a lot of questions under item 17, but as we've seen right through the discussion since yesterday, the situation of the judiciary is critical to the moving forward of the rights-based culture in the Maldives. I'm responsible then to put some issues or questions around item 20. I won't. Not because it's not important, but because we've covered that ground back and forth, many different directions over the last couple of days. And so I welcome any further information in response to item 20. You don't really give any information in the written response. You just cite the reservation about which we've already spoken. But I will leave it there without for a minute suggesting that the matters under 20 are not important. Finally, I'd like to raise an additional question. And it concerns the application of Article 20 of the Covenant. Article 20 is the requirement on the State Party to prohibit certain forms of extreme expression which trigger violence, discrimination and so forth. It's the well-known prohibition that states assume when they ratify the Covenant, and the Maldives has not reserved, I understand, on Article 20. But information has been brought to our attention regarding recent incidents of the expression of religious hatred, which do not appear to be under investigation or subject to prosecution in a manner which would raise concerns about the state's commitment to implement Article 20. Let me read out to you from a piece of material brought to our attention, and I'm quoting. Incitement of religious hatred has increased since November 2011, starting with the public protests over the erection of cultural monuments from South Asian countries during the SARC summit. On 12 June 2012, a pro-government television station, DHI-TV, alleged to have received documentary evidence that MDP had conspired with a British national to blow up the main Islamic centre in the country and replace it with a cathedral. Improbable stuff, I'm sure you'll agree. Despite a refutation of this allegation when it first surfaced 3 years ago, the DHI TV story was relayed by other pro-government media outlets. And so on the information goes. So it'd be interesting to get your comment on the specifics, but more generally, I'd like to hear a sturdy reaffirmation from the State Party that it will vigorously police its responsibilities under Article 20, and that it will demonstrate that by the appropriate investigations and prosecutions when necessary. Thank you.
Thank you, Mr. Flaherty. I now give the floor to Mr. Telling.
Thank you, Madam Chair. Before I enter into two issues, 18 and 25, which I would like to raise, I would like to responses which are given in a very open and constructive manner, and we all recognize that the political situation is not always as we would find it. It goes for many countries, and if you have a coalition government, I certainly appreciate the problems that you have, but I do not doubt that you will with vigor bring home the points that we have tried to raise, and I appreciate your confirmation on that. Issue 18 deals with trafficking, and we put questions covering both, obviously, sexual exploitation side of it and the migrating worker. It is a serious matter, and I've taken note of the written answer, but I cannot help but say that in this instance, it seems to me that the Human Rights Commission's report gives more flavor and more concern to the problems. And I'm referring to page 29 and onwards in the Commission's report of June this year. It seems when I read that there has been some actions in 2009, recommendations put forward, but not being acted upon, which seems to cause concern. In the interest of time, I will not repeat what is in it. The delegation can find that out for itself. And that brings me to the first reply in paragraph 106. Again, there is a piece of legislation which is resting somewhere, but this is probably resting before Parliament since it's still on the technical drafting stage. I just on this would like to have an indication when you think it will be ready to be dealt with by Parliament. And I again here, I notice your reply on other pieces of legislation that you will try to push through as best you can. What is surprising, I think, in your answer is the fact in paragraph 117, when you say that you do not have any baseline data available to assess human trafficking issues. I think that's somewhat surprising because in the report of the Human Rights Commission, indeed, you would find data in paragraphs 64 and 65 and so on. So there seems to be a disconnect, if you will, between the Human Rights Commission's assessment and what the government has. And certainly you will do whatever you can in order to bridge that. It seems obviously that when you then in paragraph 107 put forward the fact that you do have a human trafficking action plan studied in 2011 and goes on until next year, it begs the question how you can address a problem if you don't know the magnitude of it. So obviously you need to get I suggest your facts the facts together in order to make that an effective plan when it's being implemented. Another matter is, which I will seek clarification on, in paragraph 108, you state that there aren't any safe houses for victims of trafficking, but they are held in protective custody. I just want to know what that is. Is that means that they're locked up in ordinary police detentions, holding cells, or what is protective custody? I just want to know that. I note also that you are very responsive to adhering to and adopting various international instruments. Again, that's very helpful. And one which is mentioned here is the UN Protocol to Prevent, Suppress and Punish Trafficking in Persons, which of course is an important instrument, and you envisage there that it should meet with parliamentary approval by mid this year. Well, the mid has passed, and I just want to know whether we can have an update on that. This is paragraph 111 in your reply, whether there has been a movement. I don't know whether your parliament is in session or in recess at the moment. I think that is, to sum up, a serious matter. Some 30,000 undocumented migrant workers resides in your country. That's a large number. If you compare that with your just under 400,000 in the population. That gives a very staggering percentage. So that alone, I think, calls for serious attention to the matters. And I'm grateful for your reply, but I think it needs to be strengthened and reinforced. Finally, issue 25, which is more or less a standard question from our part. I got the answer on the non-involvement of NGOs in your reply. I just want to say, well, for the next report, I take it that you will involve civil society because it's helpful. Because we don't then get the kind of contrast between the state reports and what's in the NGO field. You did not know what to do about disseminating the report. And of course, it's even more important when we will now adopt our concluding observations that is brought to the attention of the public. And of course, in addition to disseminating it generally, posting it on the official website of the government or whatever, I suggest that you need to do some targeting dissemination as well. I'm thinking obviously of the judiciary, I'm thinking of the bar, and I'm thinking obviously of important representatives of the civil society in order to give the full width and breadth of what this committee has said in order for civil society to be helpful next round again. So I look forward to this. Thank you,
Mr. Salvielli, you have the floor.
Thank you very much, Madam Chair. And thanks again to the delegation for the dialogue, the conversation that we're having. I have a few comments on freedom of expression. Given the time, I know that our time is brief. I shall be brief myself. I'm sure that you'll have seen the report of the National Commission of Human Rights. This detailed report lists 15 events of attacks against the press, which I think are fairly serious. They occurred over a 2-year period. And in the information provided to us by the state in the responses to the list of issues, the perpetrators or servants were involved apparently regarding perhaps law enforcement officials. Of course, our work on freedom of expression is very clearly set out in our general comment number 34, and I would urge the state parties to take that into account regarding regulations on freedom of expression as regards what's happening in your country. Thank you very much.
Thank you. I now give the floor to Mr. Ben Achu.
Merci, Madame la Présidente.
Thank you, Madam Chair. I had 3 questions. One on migrant workers, but it's Mr. Tellin who already put the questions and I won't repeat it. The second was on the press, which is a question that was put by Salvioli, so I won't repeat that question either. Therefore, I will focus on my third question alone, which relates to paragraph 20 on the freedom of religion. I think in general terms, Islam has no problem with the freedom of religion, or at any rate, the freedom of religion in the Covenant on Civil and Political Rights goes much deeper than that interpretation. While the Covenant does not explicitly recognize the freedom to have a religion or to change one's religion. The Committee on Human Rights, however, in a very important general comment, number 22 on Article 18, specified the meaning which it intended to give to Article 18. And I can just read two sentences from that general comment, number 22. The first is under paragraph 2 of the general comment, which says that according to the Committee for Human Rights, the Human Rights Committee, and I quote, Article 18 protects theist, non-theist, and atheist convictions, as well as the right to belong to no religion or conviction, end of quote. And the second one is from paragraph 5 of this general comment. The committee observes that the right to have or adopt a religion or a conviction necessarily implies the freedom to choose a religion or a conviction, including the right to replace one's current religion or belief with another, or to adopt atheist views, as well as the right to retain one's religion or belief. End quote. Allow me to say that the general spirit of this general comment, which I believe to be a very important one in the committee's jurisprudence, goes in the same direction. That is to say, the freedom of religion is not the freedom granted to others to practice their religion, but rather to grant the members of one's own religion to change that religion if they so wish. Now, the question that I would like to put to the honourable members of the delegation of the Republic of the Maldives is the following. In the framework of the Constitution of the Maldives, how can this interpretation of the covenant, which gives a very broad interpretation of freedom of religion, be reconciled with the provisions of the Constitution of the Maldives, which does not allow citizens of the Republic of the Maldives to change their religion? How can these two approaches be reconciled? We have on the one hand the respect for the Constitution, and on the other hand the respect and the compliance with the covenant to which the Republic of the Maldives is striving for. Thank you.
You have the floor.
Благодарю вас, госпожа председатель.
Thank you, Madam Chair. I have just 2-3 questions on paragraphs 21, 22, 23, and 24, approximately. In Article 32 of the Maldive Constitution, it says that each individual has the right to freely and peaceably assemble without any prior authorization from the state. Now, my question is the following. Does this also encompass demonstration and marches? And if that is the case, then could you explain how it is that demonstrations are dispersed? We have received such information, and indeed the delegation itself has said that a recent demonstration, or at least part of the demonstrators in a recent demonstrations were not permitted to join but had to stay outside a fence. Could you explain how this is reconciled? On Article 23, paragraph 23, the Article 7 of the Constitution says that each individual has the right to freedom of opinion and freedom of expression to the extent that this does not undermine the basic tenets of Islam. My question is, does this mean that in this case the underlying tenet of Islam is a restriction against the freedom of thought and the freedom of expression? And if that is the case, then could you please provide some more explanations on these limitations posed by the tenets of Islam? Next question. Article 30 of the Constitution states that there is a freedom to establish political parties. It says each individual has the right to found and participate in political parties. Now, I've looked through practically all the documents, the official documents, unofficial documents, as well as other material, and I haven't quite grasped fully the situation relating to political parties, their presence or their absence, whether there's a single party or several parties. I haven't quite understood that. So could you please provide some explanation? And if there are parties in the country, or even if there aren't, how does the legislation of the Maldives establish what criteria need to be observed in order to establish a party, who is entitled to establish a political party, and what principles should guide that establishment? Thank you.
Mr. Sassenberg, I've got 3 more people who want to take the floor, and I will urge you to take no longer than 2 minutes each so that we can break at 1 o'clock. I now give the floor to Mr. Fatala.
Thank you, Madam Chairperson. I'll be very brief. My question is related to issue number 20, and here I will refer specifically to Article 9D of the Constitution of the Maldives, which provides that non-Muslim cannot become citizens of the Maldives. My question here is a very practical question. Let's assume that a Maldivian man is getting married with a woman, not Maldivian woman, French or whatever, Egyptian, who is not Muslim, and then how she can get married and not be a citizen of the Maldives, and how will be the family situation? But this is in contravention with the civil with the covenant, and I believe also with the main principle of Islam, which considers that the family is the essence of the society. It is the base of the society. And therefore, taking into consideration these 2 elements, how can you solve this issue and this problem, that someone is getting married to a foreigner, non-Muslim? How do you address this issue? Thank you very much.
Thank you, Mr. Fatala. And now I give the floor to Mr. Puzit.
شكرا سيد الرئيسة. سوف أكون مختصرا. سؤالي سيادة الرئيسة.
Thank you, Madam Chair. I have some questions relating to the judgments handed down by courts. When a verdict is final, that is to say, when it relates to the executive body or the legislative body, then these verdicts seem not to be applied. What is the situation currently? Does the government intend to take any measures so the judgments handed down are applicable to all without exception? Thank you.
Thank you, Mr. Puzit. And lastly, Sir Nigel.
Thank you very much, Madam Chairperson. Also extremely brief. I thought I heard the head of the delegation say earlier that Islam is the main source for legislation, and I'd be interested to know what part of the Constitution that is said. I can see in Article 10, paragraph A, that it says, and this is in a translation prepared at the request of the Ministry of Legal Reform, Information and Arts, that Islam shall be one of the basis of all the laws of the Maldives. One of the basis. There's a lot of difference between those two things. Is this a bad translation, or would the head of the delegation want to revisit the language he used? But I do think it's extremely important for us to know which is the reality. Thank you very much, Madam Chairperson. I look forward to the response of the delegation.
I thank members of the committee for your interventions. We are almost in time for the break, and so I think that the distinguished delegation should be ready after 2 hours to come back with your responses. So we'll be back here at 3 o'clock. And I'm sorry that we have to eat into your lunch hour, but I'm sure that is something that you welcome.
Yes, thank you.
A longer break than 10 minutes. Good. The meeting is adjourned.